Thank you, Lasky Hirlock. And I too would like to welcome our visitors to our gallery, and I'd like to say congratulations to Senator Sapone. I didn't speak on that First Amendment because I am going to speak considerably on this point, on this substantive point, and I don't plan to be speaking during other substantive points, but this is an issue that's very close to my heart. I particularly would like to thank my colleagues, Senators Fiach McAneil and Catherine Sapone, for supporting me in the grouping of amendments that I have, and I see colleagues have similar intentions with the amendments that they have put forward. And I want to thank you, Minister, for engaging with us. And I'm going to note to you now that I am going to outline my rationale today. I don't intend to push it to a vote today. I do intend to push this, or a format of this, to a vote at report stage. I feel very passionately about this issue. Minister, this amendment, indeed the rationale behind the amendments I've tabled to this bill, derives from what will be Article 42A1 of the Constitution, Supreme Court judgment depending. The state recognises and affirms the natural and imprescriptible rights of all children, and shall, as far as practical, by its law, protect and vindicate those rights. I spoke in my Irish Daily Mirror column yesterday, Minister, about Ireland's shocking record when it comes to the treatment, the welfare and well-being of children in Ireland, especially vulnerable children, whose vulnerability we seem to systematically compound. I noted the significance of the successful passage of the children's referendum on the 10th of November 2012, where, by seeking to incorporate the Irish constitutional law, that children have rights as individual human beings that are independent of adults, and that their best interests and opinions are vital when important decisions are being made about their lives, and the Irish people have spoken out and have spoken up for children. To my great frustration, these principles, which Ireland is already bound to respect under the UN Convention on the Rights of the Child, have not yet taken constitutional effect because we're still waiting a final decision by the Supreme Court to the legal challenge against it. I'm very aware, Minister, of the pressure and backlog of the cases experienced by the Supreme Court, but there is part of me that wonders why, after 26 months' delay, we do not have a public outcry. Despite our systemic change in mindset over recent years, we do still have a long way to fully embrace the urgency of children's rights. It's very clear to me, having actively engaged at all levels of the consultation and debate around the wording of the constitutional amendment, that it was both the intention of the legislature and of the people in passing the referendum to ensure that children's rights in the Constitution are vindicated, and thus we will safeguard and vindicate their rights in all future legislation. Minister, the UN Convention, which Ireland ratified in 1992, sets out an integrated and holistic approach to the rights of children, and it's internationally accepted as a model of implementation at domestic level. As far as I'm concerned, in the drafting of any bill which impacts on children's lives, it's now incumbent on us as the legislature to ensure the best interests of the child are the paramount consideration, the views of the child are heard when key decisions are made about their lives, and the evolving capacity of the child is facilitated. I believe that this bill, specifically Section 11, as currently drafted, fails to safeguard and vindicate children's rights in accordance with international law and the constitutional provisions. In fact, the rights of children under the age of 16 are not even open to consideration. So if I come, Minister, to Amendments 15 and 17, gender recognition is an established human right, which children, as individual rights holders, should be entitled. In preparing for this debate today, I've looked for commentary or evidence about the age at which gender identity develops. Two things struck me. There is a real dearth of research into transgender children. In fact, there is no incidence or prevalence data from Ireland or the UK on the number of trans young people under 18. Of the research that was available, though, Minister, I noted that some paediatric specialists put the age of gender identity in children, whether transgender or not, as young as 2 or 3 years. Other research, which I probably find easier to understand, Minister, and probably in my thinking, cites gender identity development as occurring between 3 and 5 years of age. Elizabeth Riley et al. Published a very interesting piece of qualitative research on the issue, which solicited the views of transgender adults about the needs of gender-variant children and their parents. In the Journal of Sex and Marital Therapy, the peer-reviewed scientific journal, which was published by Routledge in 2013. It found that 94% of transgender adults had identified their gender before the age of 18. 94%. 48% had identified their gender between 0 and 5 years of age. So think of that, between 0 and 5 years of age, 48% have identified their gender. Indeed, between 6 and 12 years of age, 44% have identified their gender. 2% between the ages of 13 and 18, and only 2% after the age of 18. 4% of the respondents did not reply. So I think that's a pretty good indication to us of what period of a child's life that we are looking at where they identify their gender. And that, for me, goes to the essence of what we're talking about here. And preparing for today, Minister, I was trying to think back, and I'm sure Senator Norris would be able to eloquently talk about this, that at a time in Ireland in the last century, we believed it wasn't until you were in adulthood did you make aware of your sexual orientation, that it was something that you decided, you determined. In fact, thankfully, as a society, we are more enlightened now and we are more understanding of the reality. When it comes, for me, to gender recognition, I still think we're back there in that thinking. And I would like us to understand that it really is actually at an earlier age that your gender identity is realised and understood. And we need to accept that. And that, for me, is why, Minister, when I'm looking at the bill, that actively excludes children under 16 from the provisions of this section to make an application for a gender recognition certificate. It denies outright any consideration of their best interests in the context of their personal circumstances. And for me, and I believe, legal advice will show you, it runs contrary to the best interests of the child principle. A good example, Minister, of this, how this outright denial has serious implications for the trans and intersex child is seen in S and on board Uachtarála in 2009 case. Here we had an intersex child born abroad who had been registered as female at birth, was subject to a foreign adoption order and brought to Ireland to live with their adoptive family. Upon examination by medical experts in both Ireland and the US, it was concluded that this child would most likely identify as a male, and the decision was taken by his parents to raise him as a boy. The parents sought an amendment of the Register of Foreign Adoptions so that his paperwork would reflect his gender of rearing and that he might be registered for the local boys' school. The Adoption Board refused the application on the basis that it did not believe it had the authority to grant this request. However, on judicial review in the High Court, Judge Sheeran granted the request. The difficulty is this was an extempore judgment and not a precedent. And Minister, I'm concerned that another judge, even in a similar circumstance, might feel that they lack the authority to grant such an order, given the discourse around this area. In fact, Minister, I'm actually worried that by bringing in this legislation and being deliberately silent about children under 16, we are sending a clear message to the courts. You should never grant an order. And I would like advice, Minister, and I will be seeking advice, because by actually being silent on this issue, this case that I've given you, I actually think the judge would have found it extremely difficult to make that order, which everybody agreed with. The parents agreed, the child identified themselves. So we would be saying, you know what, we know best, you go to a girls' school. Now, say that to a young boy. You go to a girls' school because we know best what's good for you. We know the best interests. For me, the best interest of that child is to be allowed to be identified as the gender that they wish, that their parents concur with, and should be allowed to go to education that they wish. Minister, if we look at international precedent, in October 2013, Argentina's government granted transgender 6-year-old Luna, formerly Manuel, a female identification card and amended birth certificate under their groundbreaking gender identity law that allows people to change their names and sexes without a doctor or judge approval. Under the country's gender identity law, Individuals have the right to the recognition of their gender identity. Individuals are also legally entitled to the free development of their person according to their gender identity, and to be treated according to their gender identity, and particularly to be identified in that way in the documents proving their identity in terms of first name, image and sex recorded there. According to law, gender identity is understood as the internal and individual way in which a gender is perceived by persons that can correspond or not to the gender assigned at birth, including the personal experience of the body. This can involve modifying bodily appearance or functions, but it can also include other expressions of gender, such as dress, ways of speaking and gestures. Minister, I have heard this is progressive legislation. As I stand here, they are standing in Malta debating their legislation. That is progressive legislation that looks at the lived lives. That, for me, is what we should be aspiring to, that really looks at the lived lives. They allow up to the age of 14 to decide. And I said, OK, how do they deal? Because maybe they don't have the issue that we have in Ireland with single-sex schools. The majority of state secondary schools, which start at the age of 11, are single-sex. Malta is very able to deal with this issue and ensure that we act in the best interest of the child. Minister, I'm concerned in particular with the mechanisms that we need to have in place to minimise the challenges that trans and intersex children currently face in Ireland. For example, as I said, the segregated nature of our educational system and the requirement that parents submit birth certificates for registration. Obviously, education is one specific, but there are other settings that children find. So we may find a workaround, and I know one of the amendments coming up will be regard to education, but there are many other places that children find. And for me, for example, I was looking and preparing for today, and in California, in January 2014, so a year ago, Assembly Bill 1266, the School Success and Opportunity Act, came into effect in the public K-12, which is 4 to 19 years of age, school system. The law inserted the following provision into the existing education school. A pupil shall be permitted to participate in sex-segregated school programmes and activities, including athletic teams and competitions, and use facilities consistent with his or her gender identity, irrespective of the gender listed on the pupil's records. So they've put that into their regulation. Yes, there was opposition, but they voted on it and they put it into their regulations. In response to the new provision, Masson Davis, Executive Director of the Transgender Law Centre in San Francisco, said, now every transgender student in California will be able to get up in the morning knowing that when they go to school as their authentic self, they will have the same fair chance of success as their classmates. Trans and intersex children are inherently vulnerable because of their age and their lack of legal protection. And yet, here we are again in a situation where the state has an opportunity to lessen such vulnerability. But instead, we either choose to have a blind eye, put up this artificial barrier, when we know that, as I've shown you evidence, children are very aware, adults have said, it's in their younger years that they identify. Minister, for me, I think of the 6-year-old child who has clearly articulated his preferred gender, which has been fully embraced by his parents, his friends, his extended family and his community. Is this young child, a boy, really going to be forced to go through a girls' school, wearing a girls' uniform, using the wrong name and pronouns in order to access the education available in his locality? Because that's what we're doing, and I know these children. This is what we are doing. Are we really preparing to stand over legislation that in this case would allow unnecessary distress, embarrassment, humiliation and potentially serious psychological harm prevail in this boy's life for 10 years before he is eligible to apply to have his gender identity recognised? Legislation that fails to listen to the voice of children or consider their best interests is not something I want to stand over. A child who has clearly articulated views regarding their preferred gender, or where the child has an intersex condition which might merit a change in gender of legal recognition, should be facilitated in achieving this end, especially where all parties agree. We don't even have a system where all parties agree. And in the amendments that we have put forward, we have sought to find ways where all parties agree, and then if there isn't agreement, where that can be dealt with. In ending, Minister, the issue as currently drafted, if we look, and why I want to put in this change, 16 and 17-year-olds will need an order from the court allowing them to apply to the Minister for a gender recognition certificate. This amendment, we're told, is designed to put the best interest of the child this amendment that I have put forward puts the best interest of the child front and centre of the court's consideration. And that's where I think it should be, Minister. I don't think it should be a medical practitioner or any psychologist or any. Allow it to be before court in order that we can ensure that the child's rights are being upheld and protected. So the amendment is to secure the consent of the person referred in section 4A, since the current drafting means the court has no authority to override the non-consent of said person, and I think we do need to have it because we do need to have the best interests of the child principle, as we do in other types of legislation such as adoption. For me, this flies in the face of the requirement to ensure that in our laws affecting children, their best interests should determine the process. Furthermore, the fact that the process towards achieving gender recognition is only open to 16 and 17-year-olds on consent actually doesn't make sense to me, Minister. Under the Non-Fatal Offences Against the Person Act 1997, 16 and 17-year-olds children can choose, if they wish, to seek medical services as part of a medical transition process in their own right. So they have the full consent to go through that medical process. But yet the bill will need their parental consent in order to apply for a gender recognition certificate. So they can undergo any medical procedures that they wish, but to get the piece of paper, we need to protect them and we need to involve their parents. It just doesn't add up. I'm genuinely concerned, Minister, about the absence of the best interest of the child. And Minister, I'd cite from the advice from the Ombudsman for Children in when the general scheme was there, said, if we have this process, it would be an illogical situation would arise in which the state would countenance a young person receiving the relevant medical treatment on the strength of his or her own consent, and yet that consent would be insufficient to obtain legal recognition of the young person's preferred gender and the outcome of the treatment. So, Minister, I think the constitutional amendment, which and I hope it does come into law shortly, Minister, but anyway, I think we have an obligation, as having ratified the UN Convention on the Rights of the Child, to ensure that in all of our legislation that we have the best interests of the child at the heart of it. And for me, the way we are actually silent about 16 and below would not allow that court case I gave you, would not allow any other court cases for a judge to use their discretion, in my opinion. Now, that is something I don't think we can stand over as legislators and trying to make sure. So, Minister, I think we need to go back to the drawing board and look at the best interests of the child and find a mechanism that everyone can agree with. But we allow children to live out their lives. Can you imagine trying to live your life as another somebody, a different identity, and somebody, you see yourself as she and they're calling you he, and you're expected to conform by wearing certain clothing, because we know with schools' education systems in Ireland, clothing is a big issue when I talk to young people. So are we really going to deny their voice, deny their best interests, deny what we know now about children, that they do have an evolving capacity, they are able to take these decisions? We can find a structure that safeguards and puts their best interests at paramount. Thank you.